Assalamualaikum warahmatullahi wabarakatuh. Welcome back to our Zoom Dekada lecture. This is part 2 for the topic terms of the contract for the course Law 1210, Law of Contract 1. So in the first part, we discussed briefly about the definition and then how distinguish terms and mere representation. And especially the courts have, at common law, the courts have developed certain factors or tests in order to ascertain whether whatever is being said by the parties actually is it terms or is it a mere representation. So we have discussed the first two in which, okay, what was the first two? And let's refresh. Okay, the first one was the time factor or lapse of time. I mean, the longer the lapse of time, I mean, the more likely that the court will say this is just mere representation and it's not a term. And we discussed about how important the statement, okay, to the parties' mind, okay, to the minds of the parties. If it's very important, then actually it is a term rather than mere representation. Okay, now we come to the third one, okay, which is the third factor or the third test, which is the knowledge of the parties. So what is meant by knowledge of the parties here? So the one who said the statement, the maker of the statement, okay, if he is in a better position to determine its accuracy, he knows better about it, whether it's correct or not. Okay, then what's the attitude, what's the approach by the court? The court has tendency to regard, okay, the statement as a contractual term, because he's the one who you make the statement and then you know the truth of it. So the court will, the court will conclude, okay, the court will takes the the tendency of the court is that yes, this is a term rather than mere representation. And we have the case law here at common law again, decision by Court of Appeal. The case is Oscar Chess Limited and Williams. So it involved sale and purchase of a second-hand car. So defendant, the dealer, okay, he sold a car. Defendant is the owner of the car. So defendant sold a car to a second-hand car dealer, and the owner of the car, defendant, he stated that it was a 1948 Morris, the model, okay, the year and the name. And actually, this is what appeared in the car's logbook. So it tallies, okay, whatever is being said by defendant, it tallies with the car's logbook, the record. But later, it transpired that it turned out that the car was in fact a 1939 model. It's not 1948 model. So the cause was brought to the court. And what's the decision observation by the court here? The court held that the statement did not become a term. Whatever is being said by the car owner here, the defendant, is not a term. Because why? A reasonable person in the position of the car dealer will not have thought that an inexperienced person would have guaranteed the truth of the statement. After all, defendant actually referred or actually double checked with the car's logbook. Whatever he said tallies with the car's logbook, the record here. And in the terms of knowledge here, who has better knowledge? Of course, the car dealer who has been selling and buying many cars as compared to defendant who only owned one car, and he just trusts whatever appeared in the car's logbook. So whatever things he said before the actual sale and purchase was being entered or executed, so it's just a mere, it's not, it doesn't amount to a term. Okay, another factor or test is that the manner of the statement, the way it was being made, all the circumstances, the court will take that into consideration. So the court is more willing, the court has tendency to infer an intention to make the statement a term, in cases where the maker of the statement has special knowledge or skill on the subject matter of the agreement compared to the other party. Actually, it overlaps, or it is, it is also, related to factor number 3. But factor number 4 focus more on special knowledge as well as skill. Okay, so it's a matter of comparison between the parties here. The case is Shawwell and Reed, 1913. This is actually sale and purchase of certain horse. Okay, those days horse is very important, transportation. Many purpose of owning a horse here. So defendant told the plaintiff, who required a horse for stud, which is for breeding purposes. So defendant told, okay, the plaintiff is the buyer. Okay, the animal, the horse was perfectly sound, okay. And a few days later, so the gap is few days later, okay, the price was agreed. So they agreed on the price. And 3 weeks later, meaning that here, after 3 weeks, okay, the plaintiff bought the horse. So the court held that whatever is being said by the defendant here, it was a term, okay. Because why? Okay, in this particular situation, defendant was the owner of the horse, so he knows everything about it. He has special skill. He has been, in possession of the horse for quite some time. Okay, so he was in that particular business or industry. So the owner of the horse actually appeared to have had special knowledge, okay, and skill as to the horse capacity. Whatever information related to the horse, he knows about it. He knows whether the horse is suitable for breeding purposes or not. Okay, he's the one who can tell better compared to the one who is buying. Okay, so I think this one is comparable, different, okay, compared to the case of Oscar Chess Limited here. Okay. Okay, the factor number 5, fifth factor, is writing factor. Or the court will look at whether the statement orally made, whether it was reduced into writing later. So when the contract is reduced into writing, so the court may regard an oral statement made before the contract was put into writing as a mere representation and not intended to be a contractual term. So mean that here first it started, negotiation started in orally made, okay, oral negotiation, oral discussion whatsoever, and later they put into writing. Whatever is being left not incorporated into the written contract, so the court will regard as, oh, you don't intend it to be term. That's why, so whatever being said earlier, it is just a mere representation. So the above case, here we are going to use the same case, okay, the same authorities here, Routledge and McKay. So the case actually illustrates, supports the proposition that a verbal statement is not subsequently included in written contract, will suggest that it is not to be treated, okay, it's not to be regarded as part of the contract. Okay, what happened in Routledge and McKay that we discuss here? Okay, the model of the car, okay, was not incorporated into the written agreement. So that's why the court held that is just a mere representation. And another factor is the interval. Okay, there are 2 factors here. Okay, we go to factor number 6. Okay, all right. So the upper factors, the 5 factors, okay, the first 5 factors here, again, it's not conclusive. Okay, it's just merely guidelines. Sometimes not all the 5 will be relevant to the facts, okay, to the problem. So again, it goes back to the real aim, the main, okay, the principal aim. Okay, what's the real aim here? The real objective is to determine, to ascertain the contractual intention of the parties. What's the real intention of them? Okay, whether the statement is intended by the parties to be term or mere representation. Okay, whether they really have intention to make it a term. Okay, because whether there's any breach later, there will be action for breach of contract. But if it is not a term, then there's no action for breach of contract. And there are also other factors. Okay, I mean, there are 5 plus 1 lah here. Okay, 6. This is number 6. Representation of effects which induce the representative to enter into the contract. Whether it really caused the representative to enter into the contract. The case is, this is local case, reported in year 1999. Lim Siu Lan and Pembangunan Hisham Sdn Bhd. So plaintiff sought, okay, declaration, so file action and asked for declaration and orders from the court. So it involved agreement for the purchase of by the plaintiff. Okay, he was purchasing a 3-story building, okay, in the defendant's development project at Setapak. And then actually, plaintiff was referring to the agreement. They signed a written agreement here. So in the recital C, annexure, okay, of the agreement. So it was stated that the building would consist of 6 blocks of 5 to 7-story shop office, and also it consists of service suites. But later, okay, it wasn't, the building appeared not to be the one stated in the agreement here. That's why plaintiff sought to terminate the agreement, because defendants scaled down the development. So to exclude the service suites, there's no service suites later. Okay, even though when they signed, the defendant promised there will be service suites. And even, okay, the number of the floors, he reduced the total floor space of the development by about 1/2. How? I mean that here, Initially, it was promised to be 5 to 7 story, okay, but later it becomes lesser, even half of it, okay, maybe 2 or 3 story instead of 5 to 7 story shop office. Okay, and the court held that plaintiff had been induced to enter into the agreements by defendant representation. So because why now plaintiff was relying on the brochure, sales brochure. Usually whatever contained in sales brochure is very attractive in order to make, to attract all the potential buyers. So the court held that where a statement is represented in such a way as to represent effects which induce the representee to enter into a contract, then such a statement intends to have contractual force and it's no longer considered as a mere representation, even though maybe whatever content in sale brochure is not really consistent, okay? It's not really incorporated in the written contract later, or maybe it's not part of the main contract. Okay. So that's the decision in the case of Lim Siu Lan and Pembangunan Hisham. Okay, this is factor or test number 7. Oral agreement incorporated into a written agreement. Okay, and this, we go to the case first, and then we are going to have a look at that. I mean, to know what's the rule is all about here, what's the factor is all about. The case, this is common law case decided by Court of Appeal, Walker Property Investments, Brighton and Walker, okay, 1947. It involved a tenant, okay, here, okay. Defendant was a tenant, so when negotiating for the lease of a flat in the house, stipulated that if he took the flat, he was to have use of the 2 basement rooms for the storage of furniture and the use of the garden. And I think this is all oral negotiation, okay. Later, they signed a written contract. Okay, when the written list of the flat was drawn up, okay, it doesn't mention about this. Okay, about the earlier arrangement or the earlier agreement later, previously. Okay, former agreement. No reference was made to either of these matters. There are 2 matters here. First, he need to use the 2 basement room for the storage of furniture. And he also want to use the garden. Okay, 2 things here, but no reference was made when he signed the agreement in the written list here. And the court held that the oral agreement should be read with the written instrument. So actually, whatever being discussed orally, okay, it is considered as part of the written agreement. Okay, they are all to be read together. So both of this thing here, they form one comprehensive contract. Okay, and another rule is that is pertaining to parole evidence rule. Okay, where the contract is made partly in writing and partly by word of mouth, meaning half by writing, half orally made. So extrinsic evidence may be brought in, or which is known as parole evidence rule. Meaning here we can apply parole evidence rule. What is parole evidence later? Okay, next slide. So the court will then infer that the parties intended that the document would be read in conjunction with their oral statements. So it depends on the parties' intention here, whether we need to take together, to give effects together, written and oral together or not. So what is parole evidence rule here? It is also known as extrinsic evidence rule. Under parole evidence rule, oral evidence is not allowed to be adduced if terms of the contract have been reduced to writing. But for this case, the court didn't apply parole evidence rule. Okay, because if it is applicable, then oral agreement will not be read together with the written instrument. Okay, so again, it goes back to what's the real intention of the parties. Actually, parole evidence rule is a long discussion on its own. Okay, it requires another topic actually. Okay, of discussion. Okay, we also have a local case on this issue. Okay, on this subtopic. The case is Goh Gok Hoon and Yusof Brothers in Berhad. This is a decision by High Court reported in 1990. So the court made it clear that where certain terms, for example, in this case, restriction on subletting, okay, was conveyed to the respondent only after the tenancy agreement had been concluded, meaning it comes later, whatever conditions attached to it. and he had no notice of it at the time when he gave the letter of acceptance. So whatever terms here against subletting did not form a term of the contract, and the respondent was not bound by such a restriction. And here, it involved letting or tenancy here, but there's a restriction. I mean, you rent out or you become the tenant, you cannot sublet, okay, this premise or property. But here, this condition, okay, this agreement or this restriction was only conveyed later after the tenancy agreement had been signed or concluded. So the court said, no, we cannot give effect to it, okay, here. Okay, so respondent, the tenant here was not bound by such restriction. It comes a bit late later. So it's not part of the tenancy agreement that they have concluded earlier. Okay, we stop here. We are going to continue with part 3 to discuss conditions, warranty, as well as intermediate or innominate terms. So I stop share for a while. So Assalamualaikum warahmatullahi wabarakatuh.